Hello everyone, welcome to the Makri Virtual. Hope you are doing good. Today I'm going to continue with the same module, that is a business skill for e-commerce, and the chapter number 9, that is a digital copyrights. In the last class we have finished with chapter number 8, that is e-commerce and online publishing. That chapter is related to what is online publishing and how e-commerce and online publishing are related with each other. That is how online publishing or how e-commerce helps in the online publishing, or how to upload the document, how to publish the documents on the internet, or how to upload any document over the internet. That is chapter number 9, that is digital copyright. So this is chapter number 9, that is digital copyright. These are the various topics in this chapter. So let's start with the chapter number 9, that is the digital copyrights, and chapter number 8 will be finished, have been over. That is a chapter number 8, that is e-commerce and the online publishing. So now let's start with the chapter number 9, that is digital copyright. Let's start with the structure, that is what are the contents in this chapter. So the first topic is objectives, that is objective, then introduction, then economic aspect of digital copyright protection, that is why there is a need for the protection of the digital copyright. Then what is the history of digital copyright, how it is being implemented in various countries, that what is the usage of digital copyright. Then property aspect of digital copyright, then authorization or authorship aspect of digital copyrights, then what are the various matters in copyrights rights, then relevant copyright exceptions, who can claim a copyright object that is covered by the digital copyrights, then works that cannot be covered by the digital copyright, that is what are the limitations or what are the key areas in which the digital copyrights is not mandatory or it's not applicable. Then guideline principles, that is what are the principles for digital copyrights, then market protection through business strategies, then summary, then keywords, self-assessment questions, and then suggested reading. So these are the various topics that is covered in digital copyright, that is chapter number 9. Then first of all, let's start with the objective, that is the first topic, that is the objectives. This says, in this age of the internet and the speed of technological development has been outspaced the legal systems, and that digital copyright issue that need to be resolved with urgency. So that is the objective, that is the first topic, that is what is the main objective of digital copyright. So with the advancement of the technological development that is outpaces the legal system, that has developed the legal systems, that digital copyright need to be resolved with the urgency. That is the main objective. That then after going through this lesson, that is after studying this lesson, you will be able to understand the concepts of copyright, that is what is a copyright and why it is useful in the copyright, or why it is useful for the various organizations, individuals. Then identify the various issues that is involved in the copyright, that is what are the various issues that is available in or that is applicable in digital copyrights. So, and then first of all, introduction, that is the introduction to digital copyrights. So this says, copyright is a form of protection that is provided by the laws of United States. So copyright is a nothing but a form of protection. Form of protection means it is a form of protection that protects a company, and this protection laws is provided by the laws of the United States, that is a US code, that is a title number 17, to the authors of original works of authorship. So that is a form of protection that is provided by the US states, that is also known as the original works of the authorship. That includes library, or sorry, literacy, that includes the literacy, dramatic, musical, artistics, and can certain intellectual works. So this can include, digital copy can include the literacy, what is the literacy and how it is useful, dramatical, musical, artist. So these are this copyright can be applicable in any of the application, any of the field, that includes the artist, that includes the literacy, that includes the musical and other intellectual works. This protection is also available to both the published and the unpublished work. It is not applicable to only the published work, it is also applicable to the unpublished work also. This is applicable to both the published as well as the unpublished works. Section 106. So this is the various sections that is available of the 1976 Copyright Act. Generally gives the owner of the copyright the exclusive right to do and to authorize others to do the following. So this provides, or this gives the owner of copyright the exclusive right to do and to authorize others to do the following. So what are the main content, or what are the main role, how it is used, and how it is authorized others to do the following. What are the various ways? So first of all, to reproduce the work in copies or phone records or phono records. That is, digital copyright is used or authorized the other to reproduce the work and to for the phono records. To prepare derivative works that is based upon the work. That is preparing the derivative work that is also based upon the work. Then to distribute copies or phone records or phono records of the work to the public by sale or by other transfer of ownership or by rental, lease or lending. So that is a distribution of the copies or phono records of the works to the public by sale. That is transferring the records or distribute the records of the public by sale or transfer of the ownership by rental, lease or lending. And then it is also perform the work publicly, that is it performs the work publicly, that is common to each and every one, that is in public. So it is applicable to the musical, dramatical, chronological works, pantomimes and the motion pictures and other audiovisual works. To display the copyright work publicly in case of this one, this one, this one. Then in the case of sound recordings, to perform the work publicly by means of digital audio transmission. So this is copyright is applicable to all the places, to all the applications, to all the public images. In addition, certain authors of works of visual art have the right of attribution and integrity as described in Section 106A of the 1976 Copyright Act. So these are the, or there are various integration. These are the various. There are various attribution that is get together or that works together for the Copyright Act. That is the 1976 Copyright Act. And these rights, however, are not unlimited in scope. This is limited in the scope. Sections 107 through 121 of the 1976 Copyright Act establish limitations on these rights. In some cases, these limitations are specified exemptions from copyright liability. One major limitation in the doctrine of fair use, that is one of the major limitation that is digital copyright is not applicable, is the doctrine of fair use. That is a doctrine of fair use that is applicable, which is given statutory basis in the section 107 of 1976 Copyright Act. In other examples or in other cases, the limitation takes the form of a compulsory license. That is, there are some form of compulsory license that is the license is very compulsory in case of the digital copyrights. Then what are the economic aspects of digital copyright protection? That is, what is the economic aspect or what is the aspect of the digital copyright protection? This says intellectual property laws are typically linked to a discussion of the values of intellectual creativity and society's use of information and ideas. So whenever or whatever we use, or whenever we use the intellectual property laws that is related to the, or that is linked to a discussion of the values of intellectual creativity, so that is applicable or that is valid for the creativity and the society's use of information and ideas. Nevertheless, they are fundamentally economic measures, and their implementation and the enforcement can and indeed should be evaluated in terms of their effectiveness in achieving desired market changes. So whenever we use the various laws that is covered under the digital copyright, for example, the intellectual property laws, that also affects the various market, that affects the desired market changes. In this chapter we do just this. The ultimate end of intellectual property laws is to promote the creation of the knowledge and useful art. That is how to promote the creation of the knowledge. That is how to create the knowledge and how to use the useful art. That is, what is the art that is used for the digital copyright. The ultimate end is to promote the creation of the knowledge. That is simply promote the creation, how to create the knowledge. That is the main aim of the intellectual property law. This goal, however, cannot be achieved without incentives, which most often are economic. We examine the issue of digital copyright by focusing on the law's intention to protect the market for copyright owners. Therefore, any measure to enhance digital copyright have to be evaluated in terms of how well it accomplishes this. Nevertheless, far more than the use of legal and artificial market barriers, this chapter advocates the essential role of strategy in resolving the copyright debate. The most efficient allocation of resources is obtained, that is the most important method of allocation of resources is obtained when markets are competitive with each other. So whenever there is a competition in the market, that is the most efficient allocation of resources. In other words, when the prices are determined by the demand and supply and fully reflect the cost of producing a good. So if I say the efficient allocation of resources, that is a perfect allocation of resources, that is only obtained when the market is when the markets are competitive. That is, if there is a competition in the market, so there is a most efficient allocation of resources. That is, in simple terms, when the prices are determined by the demand and supply and fully reflect the cost of producing a goods, its opportunity cost, society valuation for the goods, as well as other use of the same resources. To achieve the maximum efficiency, that is, if I want to achieve, or if anyone want to achieve the maximum efficiency, the market forces must not be inhibited by the external measures such as taxes, artificial barrier to entry, and other measures that affects the level of market power of either seller or buyer. The need to protect intellectual properties to the extent that we abandon competitive market mechanism has less to do with the fact that we create or we value creativity so highly, but because ideas when discovered and put in words can be easily copied, often without incurring additional efforts and time. Disseminating ideas is desirable and necessary for the prosperity of the society. For example, teaching a new and improved farming technology to neighbors increases overall agriculture production without restricting the inventor of the new method from reaping benefit on his or her own by using the same technology. So whenever there is a new technology, whenever there is a new demand, new improved technology for the farmers, that increases the agriculture production without restricting the inventor of the new method from reaping the benefits of land by using the same technology. However, once ideas are written down in physical forms, which are then traded, the ownership right of an idea and its physical manifestation in various forms because an economic issue first set forth formally in the copyright legislation of the 16th century. Then the next topic is economic history of digital copyrights. That is, what is the history of digital copyrights, how it is being used. That is the economic history of digital copyrights. So this economic history of digital copyrights includes that is, copyright is byproduct of a mass printing process. That is, byproduct means it is a mass printing process, means that is a bulk printing process that improves the literacy and market incentives for profits. Its statutory specifies have historically evolved in the context of book trade, emphasizes that property aspect over the more intellectual perspective. That is, the digital copyright also includes or the basis of the property copyright that includes the various property that includes the legislation for the intellectual property right. In today's age of information and digital products, much fear that copyright laws which were formulated to regulate the book trade are grossly inadequate, pointing out that digital media are fundamentally different from the paper medium in both production and distribution. As a distribution or printing press forced the society to rethink about the intellectual property 4 centuries ago, the digital communication again compelled to reevaluate the purpose and practice of copyright. laws. So this history says whenever there is a use of digital copyright, so whenever there is a demand for the IT, that is the information technology, so that most compel the re-evaluation of the purpose and the practice of copyright laws. That is what is the main purpose and how the copyright laws have been put in the practice for the digital copyrights. In an effort to continue to protect authors' rights in the digital era, new technologies and tools are being developed specifically to control the digital transmission. So new technology and tools are being used or have been developed to increase or to secure the digital protection. However, the development of comprehensive implementation scheme for digital copyright must go over the overall purpose of such measures. So this says history simply says that in the growing phase, whenever there is a demand for the copyright protection, so there is a need for the intellectual properties, intellectual copyrights that issues the modern publishing industry. Then the next topic is the property aspect of digital copyright. That what is the property aspect, how the digital copyright or what is the aspect that is related to the property that is the intellectual property of digital copyrights. An idea, knowledge or intellectual activity as an economic property is a relatively modern invention. So if I say the intellectual activity, that is a new technique, that is a new information, that is a relatively modern invention that is used by the most of the persons. That is a digital copyright. So an idea, knowledge or intellectual activity as an economic property is a relatively modern invention, that is a new invention that is used in the digital copyrights. It is quite clear that laws governing property gives an owner the exclusive right to process, use and transfer property and other objects that are connected to or derived from that property. So it gives the right or digital copyrights on the intellectual property rights, gives the owner an exclusive right to process, use, that is how to possess, that is how to take, how to use and how to transfer the property that are connected to or derived from that property. Suppose I own a building. My building is related to one of the farm house. That is, it is connected to one of the farmhouse. So that is also my property. So it's my usage. It's my wish how to process that, how to use that, and how to transfer the property to other owner if I want. So it is the role of the owner only how to pass, how to formulate, how to possess, how to use, and how to transfer the property from one to another. But while physical property such as acres of land or a house can clearly define, so what is an intellectual property? So in order to establish property rights, we need to first identify the owner and the property. So whenever I want to use the property rights, so it's better to first of all identify who is the owner of the property and what is the property. It may be a land, it may be a building, it may be a machinery. So what is the property or how to identify the property? So it's better to identify first of all the owner and the property. The owner is the author. As I know, as I told you that owner is simply a author that is using or that has a property that has owned the property that makes the payment for the property. That is an author. The owner of an intellectual property is the author, but because of the intangible nature, ownership cannot be established over an idea. So because of intangible nature, suppose I have an idea that is intangible in nature, that cannot be touched. If I have an idea, it's in my mind, not I can touch the idea. So the owner of the intellectual property is the author, and because of the intangible nature, ownership cannot be established over an idea, and therefore property rights are awarded to the physical expressions of the author's idea such as book. That is, the intellectual property is only applicable to the physical content, not applicable to the intangible content. Despite being called property, intellectual copyrights or intellectual properties are quite obvious or quite different from the tangible property. So intellectual property are quite different from the tangible properties, and therefore legal protection and prosecution based on the copyright laws and are substantially different from other property laws. So intellectual property is mainly applicable for the physical content, for the physical role, so that it can be applicable for the legal protection, it can be applicable for the copyright laws. This difference was highlighted in the consumer hacker in case of the US v. Archies in 1990. The prosecution tried to apply IATSP, that is the Interstate Transportation of Stolen Property, that is related to the computer hacker. However, the Supreme Court has previously stated that copyright material does not meet the scope of ITSP. This is one of the important lines, that copyright on the other hand does not protect the property itself, but rather it rather the interest of the author, especially the market or profit interest. The first known copyright theft occurred when Harmendius copied Plato's speeches and sold them overseas. Was this is a crime? So there is a question, was this is a crime or not? Then what is the authorship aspect of the digital copyright? That who is the author or who is the owner of the digital copyright? So once an idea is attached to a physical object, so once an idea is related to the physical object, for example, when it has been set down on paper, establishing the ownership of that object is a legal question. That is, establishing the ownership of that object means who is the owner of the object. That is a legal question that most legal regimes are quite accustomed to dealing with. That is, first of all, the idea has been generated. Then once the idea has been generated or is attached to the physical object, so that we can apply the digital copyright to the physical object. Then establishing the ownership of the object is a legal question. That is, who is the ownership or who is the owner of the object. That is also a legal question. So establishing the ownership of that object is a legal question that most legal regimes are quite accustomed to dealing with. Throughout the history of the digital copyright or copyright issue, so whatever the history of the copyright laws, the ownership right to an object to which an idea is attached has been a far less contentious issue than the question of ownership right to an idea. For example, when one wrote down public speeches of Plato, the manuscript belonged to a translator, not the owner. This is one of the best examples. So when anyone or when one or any person write down the or wrote down the public speeches of Plato, that is, what is the public speech of Plato? The manuscript belonging to the transcriber, not the author. So whatever the manuscript that is applicable, that is belong to the or that belongs to the transcriber, not the author of the Plato. The former should legally duplicate and sell the speeches. Historical records do not in fact show whether the author or the government objected to this practice or recognized the issue of authorship at all. When authorship is not exerted, copying speeches could by no means be considered as an act of theft. So whenever there is an issue that is not related to a theft. So due to the property aspect of intellectual properties, copyright laws is involved as a trade regulation. So copyright laws is also considered as a trade regulation. However, intellectual properties have different characteristics unlike other physical properties, and accordingly, copyright laws are enforced differently. Damage awards for copyright theft, for example, are based on actual and potential market loss that is inflicted by the theft, not the recovery of the stolen property itself. As a result, the current debate on copyright protection in the electronic marketplace mainly center on whether authors have the moral right to control every aspect of their works or whether the public has a right to access this information. A clear understanding of this issue is needed. That is, how to access the information or whether the public has a right to access the information or not. Modern copyright laws accept the premise that authors who provide content should be rewarded. Then digital copyright subject matter. That is, what is the digital copyright or what is the subject matter or what is the main matter that is used in the digital copyright. So this says a copyright exists in any original work of authorship fixed intangible medium. So whenever I say an copyright that exists in the only the physical medium, that is also related to the original work of authorship. So who is the author and who is an author? That is related to the, or the copyright is related to the physical medium or the tangible medium of the original work of the authorship. It is not related, that is the copyright is not related to the intangible content. That medium can be almost anything, including paper, computer disk, clay, canvas, and so on. So that tangible medium may be anything. That may include the paper. For example, the author has written something on the paper. That is also a document on which the copyright is applicable. Computer disk, it is also applicable for the copyright. Clay. So whatever the content, whatever the medium that we touch, that the ownership has built, then we can use the, or then we can apply the copyright on it. That is the copyright, digital copyright is applicable on it. For a work to be original, that is for a work to be original, that is whenever the work is original, it must meet two qualification. That is the two qualification must meet. What are the two qualification? It cannot be copied from another work, and it must exhibit at least a small amount of creativity. So it cannot be copied from another work means it cannot be used for another work, and it must exhibit at least a small amount of creativity. That is, it must exhibit means it must control at least a small amount of creativity. Copyright lasts for the life of the author and 70 years thereafter. So for a work to be original, for a work to be mainframe, to a work to be applicable, it must include the two qualification, it must include the two methods. What are the two methods? That it cannot be copied from another work. It must exhibit at least a small amount of creativity. So these are the two qualifications that must or that must be required for a work to be original. So these are the two subject matter that is applicable for the digital copyright. That is, if I'm saying that my document is digitally copyright, that is, it is copyright document. So it cannot be copied from another work. That is, another work or another person cannot be copied or cannot copy the work. And it must exhibit at least a small amount of creativity. That is, there must be a creativity in the subject matter that is applicable for the digital copyrights. Then the next is digital copyright rights. So what are the various rights that is applicable in the digital copyrights? So whenever we use the digital copyright, so what are the rights available in the digital copyright? So what are the digital copyright rights, that what are the rights that is applicable in the digital copyrights? So if I say that digital copyright, so what are the rights that is applicable, that is common in the digital copyrights? This says a copyright provides not just a single right, but a blender of rights that can be exploited or licensed separately or together. So if I am taking, or if I am taking the digital copyright from for my property, suppose I owned a land or building, then I issue or I request for a digital copyright, then I got the digital copyright. Then when I got the digital copyright, then not only the single right that is applicable with the digital copyright. No, there are so many rights. There are multiple rights that can be applicable for the or that can be applicable to a building, because it includes, or I own the digital copyright. So there is not a single right that is applicable to the digital copyright. There are so many rights. There are blender of rights or bundle of right, that multiple of right that can be exploited or licensed separately or together. The economic right embraced within a copyright that includes the following. So what are the economic rights that can be included, or what are the different rights that can be included in the digital copyright? The first of all, the first right is the reproduction right. So we can reproduce the content, we can reproduce the right. That is the right to make copies. For the purpose of reproduction right, a copy of a work is any form in which the work is fixed and from it can be perceived, reproduced or communicated either directly or with the aid of a machine. So we can, now this is the right that applies, that we can copy the, or we can make the work, we can make the right, we can make the reproduction of the right, or we can form the right, or we can communicate the right, we can reproduce the right directly with the aid of the machine, either with the content of the manual, either with the content of the machinery. Courts have held that even the reproduction created in short-term memory, that is the RAM of a computer when program is loaded for use, is qualifies as a copy. So this is one of the right that is applicable. So if I own the land building, so I can reproduce it, that is I can again reconstruct the building, or I can either further transfer the building, either further perceive the building, or communicate it with another one, or communicating the right of the communication, that is a reproduction right. Then right to create adaptation or adaptations or derivative works. That is the right to create the adaptation. So adaptation means adopt the new technology, or the derivative work means derive the work, derive the property from another property. This says a derivative work is a work that is based on copyright work. So if there is a copyright work that is already got the copyright, we can derive the work from that work that is based on the copyright works, but contains new material that is original in the copyright sense. For example, the movie Gone with the Wind is a derivative work of the book by Margaret Mitchell. So whenever there is any movie that is created on any book, any novel, that is a reproduction, that is a copyright work, that is a right to create the adaptations or the derivative work. So if the movie is created from any of the novel, that is a movie is a derivative work from the novel. So that is a derivative work. And then movies also get the copyright, that is a digital copyright. Why? Because this is one of the right that is applicable in the digital copyrights. Version is not a term of art in copyright law. If a new version consists merely of the same work in a new form, such as books or photograph that can be scanned to create a digital version, that it is a reproduction of the work. As I said, the reproduction is one of the major issues that is applicable in the right to create production. This is one of the best example. Windows 2000 is a derivative work. Why it is derivative work? Because most of the features that is applicable in Windows 98 must comes in the Windows 2000. So it is a derivative work, that is a Windows 2000. Whenever there is a development of Windows 2000, that is a derivative work that is based on the Windows 98. So this is one of the right that is applicable in the digital copyright. Then the next right is the right to distribute copies of the work to the public. So this is one of the right that it is also applicable for the right to distribute the copies of the work to the public. The distribution right is limited by the first sale doctrine, which provides that the owner of a particular copy of a copyright work may sell, transfer that copy. Suppose I got a copyright work. Suppose I got a one copyright work. So I can, being a owner, I can transfer my copyright work to another person, or I can copy my copyright work and give to the another person. So in other words, the copyright owner, for example me, after the sale of a copy, cannot control the subsequent disposition of that copy. Making copies of a work available for public downloading over an electronic network qualifies as a public distribution. Then the next work is, or the next right is, the right to perform the work publicly. So this is also one of the right, that the right to work the, or right to perform the work publicly. So to perform a work means to recite, render, play, dance, or act it with or without the aid of a machine. Therefore, a live concern is the performance of the musical composition, is the playing of a CD on which the composition is recorded. Then the next right is the right to display the work publicly. So this is the right to perform the work publicly. This is the right to display the work publicly. So these are the various rights that is applicable, that we can make the work, or we can display the work publicly, or we can make the work publicly. So this is, we can perform the work publicly. To perform or display a work publicly means to perform or display it anywhere that is open to the public. So anywhere means at any place, anytime that is open to the public, general public, or anywhere that is a substantial number of persons outside of a normal circle of a family and its social acquaintances is gathered. Transmitting a performance or display to such a place also makes it public. This law, or the law, differentiate between the ownership of a copy of a work and the ownership of the copyright rights. Then the next right is not all rights attached to all works. For example, some works such as sculpture are not capable of being performed. Other work, that is a musical composition and sound recording of musical composition, have rights that are limited in certain respects. For example, reproduction of musical compositions in copies of sound recording is governed by compulsory license that sets the rate at which the copyright owner must be paid. So that is all, not all rights it attached to all the works. That is, if I am saying one of the work that is not attached to the work, that is not attached to the right. Then the relevant digital copyright exceptions. So what are the now? So these are the various rights that is applicable to the digital copyrights. Now let's see what are the various digital copyright exceptions. So what are the various exceptions that is applicable in the digital copyright? So copyright rights are not absolute. They are subject to a number of limiting principles. That is, there are also some limitations, there are also some foundations, there are also some restrictions that is also applicable to the digital copyrights. So this says copyright rights are not absolute. They are subject to a number of limiting principles. There are a number of limiting principles that is also applicable to the digital copyrights or the copyright rights, and are exceptions. That is, there are so many exceptions that is available for the digital copyrights. Those principles most relevant to the creation of digital archive are as follows. So what are the various principles or what are the various laws that is relevant to the digital archive are as follows. So what are the various exceptions that is applicable, or which rights on which digital copyrights there are exception that is applicable. The first exception is the exception for certain archival and other copying by libraries and archives in section 108 of the Copyright Act. That is, this is the exceptions that is applicable for various archivals and other copying by libraries. So there are various libraries that is also applicable. So there are this is one of the exceptions that is applicable for the various archivals and other copying by libraries and archives in section 108 of the Copyright Act. Libraries and archives are permitted to make up to 3 copies of unpublished copyright work. That is, we can make up to 3 copies of unpublished copyright work. That is solely for the purposes of preservation and security, or for deposit for research use in other library or archives. The work must be currently in the collection of the library or archive, and any copy made in the digital format may not be made available to the public in that format outside the library premises. Library and archives must or may also make up to 3 copies of published work to replace a work in their collection that is damaged, deteriorating or lost, or whose format has been absolute. So this is one of the exception. That exception is also or the exception of the digital copyrights is applicable to the various archives and various libraries. So if I say the library and the archive, that must be applicable, or that must or also make up only 3 copies of the published work to replace a work in their collection that is damaged. So if any work that is damaged, so we can make only 3 copies of the published work. This is one of the limitation of the digital copyright. Copies in digital format, like those of unpublished work, may not be made available to the public outside the library premises. Even if copying a work is not expressly allowed by section 108, it may still permitted under the fair use doctrine. Next exception is fair use is the copyright exception with which people are often most familiar. Whatever a use is fair depends on the fact of a particular case. 4 factors must be evaluated when such decisions are made. So what are the 4 factors that is used whenever we make the decision that the copyright exception or the usage of the copyright exception is fair or not? The first factor is the purpose and character of the usage. That is, what is the main purpose and what is the main character of the copyright. Among the consideration is whether the use is for commercial or for non-profit organization. So what is the main purpose of using the copyrights? Works that transform the original by adding new creative authorship are more likely to be considered fair use than those that do not. The second factor is the nature of the copyright work. The third factor is the amount of the portion used. The fourth factor is the potential market that is used for the copyright. That is, what is the capturing of the market that is used for the copyright issues. Then the next limitation or the next exception is the section 117 that allows the owner of a copy of a computer program to make an archival copy of that program. So for making the archival copy of a program, who is applicable, who is the owner of the copy of the program? So next is who can claim a copyright. So who is eligible for making a digital copyright? Who is eligible for getting a digital copyright? That is the next topic. So first of all, let's take a break, then moves to this topic, that is who can claim a copyright. So let's take a break right now, then moves to this topic. So come back from the break. Now let's start the session again. Next topic is who can claim the or who can claim a copyright. That is who is the responsible or who is applicable for claiming a copyright. That who is applicable for the getting the digital copyrights. So anyone who creates a work that is covered by a copyright laws and fixes it on a substantially permanent medium automatically possesses the copyright. So this is one of the important line. Anyone who creates it or creates a work that is covered by copyright laws. So anyone who creates a work, anyone who is who create anything that is a work that is covered by copyright laws and fixes it on a substantially permanent medium. So anyone who make a work, anyone who make a document, who make a work that is also covered by the copyright laws. So if I'm making any work, if I'm creating any work that is covered by the copyright laws, and if I want to fix it on a permanent medium that is tangible in nature, so it can automatically possesses the copyright. That is, it can automatically be getting the copyright, but it is applicable for the copyright. Under current laws, a copyright is obtained as soon as possible, as soon as work is created and fixed in a medium. So under the current acts and the laws, under the current rules and regulations, a copyright is obtained. So a copyright is obtained as soon as, so as soon as it gets a work or as soon as the work is created and fixed in a medium, it can get the copyright. Unlike patents, authors do not need to claim their copyright, register, publish, or give copyright notices on their work. That is, unlike patent, authors do not want to or do not need to apply for a copyright. Automatically, they get the copyright once it is once the work is created and it is stored on a physical media, permanent media. Then automatically it can gather or automatically the copyright has been issued to their owners. Forms of copyright notice are optional for works. That is, if anyone wants to interested or if anyone wants to apply for a copyright, it's optional, but there is no requirement. Automatically they get the copyright, digital copyrights. Through agreements such as Berne Convention, copyright is acknowledged internationally as well. That is, it is a copyright is issued that is acknowledged internationally. That is, it is available at the international level. While patent have to be filed individually for each country. So it is copyright is available internationally, and the patent is available or patent have to be filed individually for each of the country. Unless a specific context transferring the right is drawn up, the copyright belongs to the actual author. Full-time employment may constitute such as contractual situations such as work for hire, where employees may own the ownership for the material created. So if there is a contractual term, that is a work for hire, that is a there is a hirement of, or there is a recruitment of the persons based on the work, where employees may own the copyright only for the material created. Suppose I create one material that is only the part-time work. That is, then I am applicable, or I can get the permanent work, or I can get the contractual work, I can get the work for hire, I can get the copyright issues. So that is only applicable for the material created. For other specifically or other specially commissioned work, that is work for the hire, a written and the signed agreement is required. So whenever I get a, for example, if I am hired for in an organization, if I hired in an organization only for some work, only for one material, and if I got the certificate, if I got the copyright certificate, so a written and signed agreement is required for that purpose. So this is who can claim a copyright. Either a full-time employee, either a part-time employee can claim a copyright, and it is applicable as soon as the work is done and as soon as it is fixed in or it is created in or it is applied to a physical medium. Then next is what are the objects, or what is the objects, or what are the different objects that is covered by the digital copyrights. So what are the, or what is the type of work, what is the nature of the work to which the, over which the digital copyright is issued, or over which the digital copyright is applicable. That is the object covered by the digital copyrights. So this says US copyright laws, that is 17 USC grants copyright protection for works of authorship in the following cases. So in the following cases, the work is guaranteed, the work is applicable, the work get authorship. First one is literary work, including books. So these are the various objects, these are the various nature of the work on which the digital copyright is applicable. One is the work that is based on the literary, that is related to the education, that includes the books, magazines, news article, manuals, catalogs, advertising words, computer software, and compilations such as directories and databases. So digital copyright is applicable on the objects, on the works, that includes on the works of the education. For example, the magazines, the books, news article, manuals, catalogs, software, compilations, directories, databases, etc. It is also applicable for the musical works, including accompanying words, and it is also applicable for the dramatical works, including accompanying musics, pantomimes, and choreographic works, pictorial, graphical, sculptural works, including maps and fine arts. So whenever there is a picture, whenever there is a graphic, that is also applicable for the digital copyright. Digital copyright is also occupied the motion pictures, sound recordings, architecture works. So these are the various objects on which the digital copyright is mandatory. Then terms of copyright, that is a work, or what is the main term of copyright, what is the duration of the copyright. So for works created in 1978 or later, the term of copyright is the author's life plus 50 years after the author's death. That is, what is the duration of the copyright. That is the works that is created in 1978 or later. So whatever the work that is created in 1978 or after 1978, the term of copyright is the author's life, that is the whole author's life plus the 50 years after the author's death. And in the case of corporate authored work, the term is 75 years after publication. So in case of the personal term, suppose I own a building that is personal, so the digital copyright is applicable till the life of me plus the 50 years after my death. And in case of corporate author work, in case of corporate issues, corporate industry, the term is 75 years after publication or 100 years from creation. Although the work created before 1978 are governed by different laws, such as work that is given us 75 years from their creation. The next is works that cannot be covered by the digital copyright. That is the next topic. So what are the various works that cannot be covered or that cannot be taken by the digital copyrights? We have studied that what are the objects that is covered by the digital copyright. Now the objects or the works that cannot be covered by digital copyrights. The first work is works are not protected if they are not fixed on a permanent medium. As I told you, the digital copyright is not applicable for a intangible product, for the intangible work. So it can be applicable only for the intangible work. So work that can or works that is not protected by the digital copyright, that is not fixed on a particular or permanent medium. This requirement is lax enough to include handwritten or typed document as fixed form of authorship. So if anyone has written something on a paper, but that is an authorized paper, that is also applicable for the digital copyright. So if any work that is not fixed, that is not fixed on a medium, that is not applicable for the digital copyrights. Then only the original work that is only the original work, not a duplicate work, are protected. So only the original work are protected under the digital copyright. The originality requirement is also fairly flexible. Unlike patents, works dealing with the same subject or idea can be copyrighted as long as each work has a minimum degree of originality. Then the third one is When works incorporate pre-existing material, only the original portion is covered by the copyright. So whenever there is a incorporate or whenever there is a corporate work that is a pre-existing material, so only the original portion is covered by the copyright. If a journal contain articles that is copyrighted by the individual author, the act of collection is copyright as the original document, original work. Then the next is facts, that is the raw material, that is my thought, my thinking cannot be copyright, because as I told you in the first point, only the permanent, only the document that is applicable or that is applied on a particular medium can be copyright. Other things cannot be copyright. So facts cannot be copyright. Therefore, compilations of names and addresses that are publicly available such as telephone book cannot be copyright. To copyright such material and databases, copyright laws requires a certain originality in selection, organization and arrangement of the data. Even then, only the original aspects are copyrights. So facts cannot be copyright. Next is works in the public domain. So if there is any work in the public domain, suppose me and my friend publicly share or publicly owns a building. So any work that is done in the public domain are not protected. Work can enter the public domain when their copyright expires. However, However, due to changing copyright laws, a careful evaluation is needed to determine whether a work in the public is in the public domain or not. So, due to the changing copyright laws, a careful evaluation is taken care of or is needed to determine whether a work is in the public domain or not. For example, previously a failure to renew or give proper copyright notice resulted in the loss of a copyright. So if I am not giving a particular or a copyright notice, that is also result in the loss of the copyright. Next is, or the next exception, that is the object that is not covered by the digital copyright is, if a work is created by the US government, it is automatically in the public domain since government works cannot be copyright. So if there is any work that is created by the US government, so government means a local or the public entity that is applicable to all the public. So that is also not covered under the digital copyright. Why? Because it is automatically in the public domain, because government is only for the public. So it is automatically in the public domain since the public, the government work cannot be copyright. However, this only applies to the federal governments. State government can copyright their documents. So if there is a state government, they can copyright their documents. The only statutory exceptions is for data produced by the US Secretary of Commerce, which has copyrighted under the Standard References Data Act, that is the 15 USC 220E. A gray area is when US government provides functioning for independent contractors. Then next is guiding principles. That is the guiding principles means what are the principles or what are the various principles that is applicable for the copyright laws. But before this, let's take a 2 minutes break. I'm just coming in 2 minutes. So let's take 2 minutes break, then come back, then starting with guiding principles. So let's take a 2 minutes break or 5 minutes break. So come back from the break. Now let's start the session again. Then next topic is guiding principles. So what are the various principles that is applicable for the copyright laws? So what are the various principles on which the copyright, digital copyright is based? That is the guiding principles of the copyright laws. First is balance in copyright law. Balance means there must be a balancing condition in the copyright law. That is, the copyright law must serve the public interest by providing a reasonable balance between the rights of copyright owners and the right of citizens to reasonable access to copyright works. So there must be a balance in the copyright laws. There must be a there must be a reasonable balance in the copyright laws that serves the public interest. That is, the public interest means that serves the common public by providing a reasonable balance between the rights of the copyright owner and the right of the citizens to reasonable access to copyright works. So copyright laws, or there must be a balance in the copyright laws that must serve the public interest by providing a reasonable balance between the rights of the owner and the right of the reasonable access to copyright works. Then the next principle is primacy of the Copyright Acts. That is, the primacy means the primary of the Copyright Acts. The rights that is granted to users of copyright content by the Copyright Act must not be allowed to unilaterally overridden by the contract. The contractual licensing of copyright works does not replace or fully achieve the public policy of the copyright law. So this is also one of the guiding principle, that is the primacy of the copyright law. That is, if there is any content that is publicly occupied, that is publicly available, then the copyright is not applicable for the publicly owned document. Then technological neutrality, that is technological neutrality is one of the another principle, that is the copyright laws must remain technology neutral. That is, the technology neutral means there is no hard and fast technology that is applicable for the copyright or that is applicable for the digital copyrights. So copyright laws must remain technology neutral in the sense that the provisions that embody ensures uh, that technological development detract neither from the rights of the copyright owners nor from the rights of the users to have reasonably access to protected works. So technological neutral is also one of the guiding principle, that is if there is any technique, if there is new invention of the technique, so that is not applicable or that does not make the impact on the digital copyright. So this is one of the guiding principle, that is a technological neutral. Then the next principle is the right to read, that the individual must retain the right to read lawfully obtained carefully or copyright content. That is, if there is any rules regulation, that must be read by the individuals very carefully for the copyrights. Then the right to lend, that is a right to lend means the non-profit public lending of legally obtained copyright content is one of the cornerstone of the democracy or democratic society and must be permitted to continue irrespective of the format of the content. So the right to lend is also one of the principles, that if there is a right, that is also lending phase, that is also applicable for the copyright issue. Then next principle is a robust public domain. That is, a robust public domain is an essential element, important element of informed and participatory society. Then facts are not copyrightable. This is one of the principle, that if I'm thinking that I think this is one of the best thing, I think this is also one of the best thing. So I think that my thought are not copyrightable. That is, facts are not copyrightable. Because the main condition is that in order to get the copyright, that must be applicable or that must be applied on the tangible medium, that is a tangible place. Then the next one is privacy. That is the right of individuals and institutions to retain their privacy relating to the choice of reading or research content must be protected. That is also the principle. That is, any right, any right of the individuals or the organizations to retain their privacy relating to the choice of reading or research content must be protected. So that the content must be protected in case of the copyright issues or in case of the copyright laws. Then next topic is market protection through business strategies. So how to get the market protections through business strategies, or what is the market scenario, market protection through business strategies. This says, by granting a monopoly power in the form of copyrights. That is, monopoly power means the single power in the form of copyright. Suppose I own a building, the same example, and if I get a copyright, so it's building is in my power, whether I can sold it out, whether I can retain it out, whether I can reconstruct the building. So it is my property, I can get the copyright for it. So by granting a monopoly power in the form of copyrights, society's intention is to protect an author's market from being eroded or stolen by the others. When the market is not protected from pirates who do not share the initial cost of developing the product, authors have a reduced incentive to develop a product. So when the market is not protected from the pirates, the market is not protected means market is not getting or protected from the pirates who do not share the initial cost of developing the product. Authors have a reduced incentive to develop a product, at least for commercial reasons. This is in the same argument used to advocate that academic research have to be funded by the governments if the quality products are desired, since non-profit intellectual activities are not protected. So this is the same argument that is used to advocate the academic research, that is used to make the business strategy that is funded by the government. Why? Because one of the main reason is that quality products are not, or the non-profit intellectual properties are not copyright under the, or not protected under the digital copyrights. Our analysis that is based on product characteristics reveal that many types of product may actually make the copyright protection issue null and void. So there are so many products that is applicable for the copyright protection that makes the copyright protection null and void. So there is no copyright protection in case of large number of products that turn their vulnerability of easy modification into a means to increase the profit through public or product differentiation. Clearly, a tight control over all aspects of copyright is not always most efficient. So clearly, a tight control on all of the aspects of copyright is not always most efficient. If the result is the creation of a complex, calculated monopolist, it may instead fail to give incentive producers to update information or to develop interactive and innovative products. Also, from the customer point of view or from the consumer's point of view, personal arbitrage via reselling is an important leverage against seller price discrimination. So this is one of the one of the different ways that is used whenever we say the market protection with through various business strategies. So what are the various business strategies, business method that is used for making the market protection or make the digital copyright for the market? Also, from the consumer's point of view, personal arbitrage via reselling is an important leverage against sellers' price discrimination. A more balanced approach can only be achieved after considering all the economic implications in the market. Economic implication means after analyzing all the costs and the benefits in the market, a balanced approach must be taken care of. For a practical solution for copyright protection in the digital world, seller and policy makers need to consider the unique type of product and consumer usage. So for making the practical solution for the copyright in this world, the seller and the policy makers need to consider the unique types of products. What are the various different types of products and the consumer usage? Depending on its type, some products may need more attention than the others. So some may need the more attention than the other one. Then next is interactive service providers clearly represent one end of the extreme with the least concern for the copyright infringement. In actual fact, these services may not have applicable copyright protection in the first place. Among non-interactive products, time-independent products represents the bulk of the primary information products that is available on the internet. Other information that are more valuable if few people have them will not share at all. So this is only the theory that makes that if any product is unique, that is not related with each other, that is not duplicate with each other, so that is very valuable and that is applicable for making the digital certificates. On the opposite end of the extreme are music, software and computer games. So these are the various objects in which the market strategies are different. Digital copyright protection is critical for these independent products. So in order to get the digital certificate, it is very difficult to get the certificate for these strategies, for these businesses, for these objects such as music, software and computer games. Sellers are still change consumer usage of these products so that they become time dependent. As is evident in the physical product world, frequent updates and releases of new and improved versions help this process. So in order to make these products also applicable for the digital process and protection, frequent updates are and the new versions are needed or new versions are applicable for this process. Similarly, with some effective uh, but not too cumbersome technology, short-term duplication can be prevented. The current content of the current relocations of the content owners to destroy their product and sell them on the internet has more to do with lack of technologies. So this says in some business strategies, in some business objects like music, software, computer games, it is difficult to get the digital or it is difficult to get the copyright protection. It is difficult to get the copyright issues that is applicable for the digital protection. Then the next case is the separate case issue exists in case of computer software. That is the next case, that is the next business strategy that is applicable for the digital protection. The gist of the issue is whether copyright or patent protection is more suitable to the software. So what is the main question? Whether the copyright is applicable or suitable to the computer software or the patent protection, which is suitable for the digital for the computer software. In general, the consensus seems to be copyright is the most effective to protect the software. That is, in general cases, the copyright, digital copyright is one of the is a better effective means to protect the software. However, some software have been recognized as being used to bring new and useful functions that cannot be that can be protected by the patents. The debate involves comparing a number of different factors. That is, there are a number of different factors that is applicable for the software that is used to get the digital certificate. So question arises, which is better? The answer is digital copyright is one of the better solution for the digital copyrights. Copyright applies immediately while a patent takes time to establish and is quite expensive to obtain. So the copyright applies immediately. That is, whenever I want a copyright or whenever I get the copyright, not apply, whenever I got the digital copyright, it applies automatically immediately. While in case of patent, it takes a time to establish and it's quite expensive to obtain. Also, a patent requires a great more in terms of originality than does a copyright. As a result, the protective right granted under patent law is in general stronger than that obtained copyright law. This said, current laws are inadequate to deal with many facts of computer software, in some argue in favor of new mechanism to protect the software. A proper legal protection for software would represent a legitimate instance to rethink copyright laws for electronic commerce. So this is just a theory and that shows what are the business strategies, what are the business applications, what are the business rules that is applicable for the digital copyrights. That is, what are the various issues that is applicable for the digital copyrights. So one of the business strategies computer software, one of the business strategies music, what are the different objects. So next is summary. So we have wind up this chapter also, that is a digital copyrights. This is summary, that is what we have covered in this chapter. This says copyright in the digital age has become one of the hottest issue that affects the future of electronic commerce. That is, copyright is one of the major or one of the important issue, hottest issue that affects the future of electronic commerce. Future of electronic commerce means the future means the advanced part of the electronic commerce that becomes the future of the e-commerce. In the first place, the majority of digital products falls into the range of expressions that is protected by the copyright law. An estimate by a computer software organization, although it has been obvious bias, puts the cost of privacy or piracy on and off the internet at several billion dollars. So this is just a summary, that is whenever there is an estimate by the computer software that makes a piracy on and off whenever there is a usage of the internet. An international effort to strengthen the existing copyright has been undertaken in December 1996 in Geneva for the first time in 25 years, that is organized by the World Intellectual Property Organization. So an improvement, or in order to increase the digital copyright, a new copyright law is applicable in the December 1996, that is available in Geneva for the first time in 25 years, that is organized by the Intellectual Property Organization, that is a United Nations agency, that is a United Nations organization in the charge of the Bern Convention. On the other hand, the culture of the internet as a free and unregulated communication medium has produced a strong counter argument for increased public access to information. The ease in reproduction and distribution of any digital product has given rise to widespread legal and technical issues. So this is just a summary what we have covered, like digital copyright, who can claim a copyright, who is applicable of copyright, object that is not covered by the copyright. Then these are the various keywords. One of the keyword is copyright. So it is a form of protection that is provided by the US state laws to the authors of original work of ownership that includes literary, that is education, dramatic, that is a drama, musical, artist, and certain other intellectual works. The next is digital copyright. That next keyword is, what is a digital copyright? A copyright, not just a right, single right, but a blender of rights that can be exploited or licensed separately together. So it is not that only a single right is applicable or it is available in case of the digital copyright. No, there are multiple rights. There are blender of rights that is available in the digital copyrights. Then the next is ITSP, that is the interstate transportation of stolen property. Then IPR, that is the intellectual property right. So these are the various keywords that is used in this chapter. Then the next one is self-assessment questions. What is digital copyright? How digital copyrights are more useful in current scenarios? What are the marketing strategies that is available for protection of copyrights? What are the various principles that is available in the digital copyrights? Is copyright necessary or is copyright mandatory? Then elaborate property and authorship aspects of digital copyrights. The next is suggested readings. That is the suggested readings, or what are the various books that is available in this digital copyrights. These are the various books. The next is chapter number 10. So this is the winding up the chapter, winding up of the today's session. That is the chapter number 9. We are winding up, or we have wind up, that is the digital certificates. So that's all for today's session. In the next class, I will be taking the next topic, that is the chapter number 10, that is intranet and supply chain management. Now, till now we have studied about the internet, that is a collection of networks. Now intranet, that is a public network. Public network means there is only a local network. For example, if in my organization there is a LAN connection, that is a intranet. So that is chapter number 10, that is the internet and supply chain management, that I will be taking in the next class, that is a tomorrow's class. So thanks a lot everyone for listening me. That's all for today's session. In the tomorrow's class I will be taking the next topic, that is chapter number 10. Now if there is any doubt, any advice, any suggestions, you can talk to me, you can make the chat. And if there is any confusion, any type of confusion in any of the modules, you can talk to me, you can chat with me, you can mail to me. So thanks a lot everyone. Bye bye. Yes, Joseph, hello, how are you? Yeah, hello Joseph, how are you? Good afternoon. Yes, tell me, Joseph. Timetable is related to what? The modules. Yeah, yeah, yeah. You want the pre module specification, that is before involving the module you want a pre schedule for the modules, right? Okay, 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 no issues. So let's finish this module within only 4 to 5 days. Then moves to or moves to next topic. Then I will share that module, that schedule for the module. Okay. So after finishing this module, I will be given you a next module pre-schedule. That is a when to start next module and when to wind up that module. Okay. So after finishing this module, not for this module because this is in current module that is in currently in running. So it is not applicable to this module because it's become hodgepodge. Okay. So you understand my problem. So after this module, I will be share the next schedule for the module. When to start, when to finish. All right. Okay. Thanks a lot. Bye bye.